Right. Good evening, everyone, and welcome to our elective module, Advanced Corporate Law. There's been a bit of a back and forth as far as the commencement of this module is concerned. Certainly, there has been this concern with respect to lack of certainty regarding the number of students who are enrolled on this module. And we, as a faculty, did not want to mount an elective module for less than 10 students. That is economically not efficient. So we are resuming continuous and formal teaching in advanced corporate law on the understanding that we have not less than 10 students who are actually enrolled on this program. So just to ensure that all of us are on the common page and we're on the same wavelength, we use 2 minutes to recap what the course outline is, and then we quickly move on to discuss our next substantive topic. Yeah, so as Dr. Tadiosinkum has told you in your earlier meeting, this course is building upon, of course, it makes no assumption that you've learned company law at the undergraduate level, because if you've not even learned it, it is still possible for you to go through this module, so long as you are prepared to do the necessary reading. So having said that, advanced corporate law seeks to explore the theoretical aspects of corporate law and selected aspects of the law affecting companies or corporations in Ghana in the context of comparative perspectives, and then the evolving company law reform debates in Ghana. So you notice that we are not necessarily going to do the linear treatment of company law, and thankfully, I would like to know that almost all of you here have actually done company law as part of your undergraduate LLB. That gives us some comfort in how we pitch the discussions that we'll be having in this module. So we take aspects of this area of the law, and our main concern is the critical perspectives and also the comparative dimension. So that is our main concern. So also of particular interest to us is a focus on insolvency law, especially cross-border insolvency law and practices. So at the end of this module, if you have applied yourself to what we seek to do, among other things, you should be able to demonstrate the leading corporate law theories, which are out there, and I'm sure in your reading, you've come across some of them. Then you should also be able to critically test the claims of some of the leading corporate law theories against the reality of corporate law and practice in Ghana and selected jurisdiction. Of course, a lot of conceptual orientation are out there among corporate law scholars. Those who bring the economic and law analysis, those who are interested in the ability of the company, for example, the corporations, to be for wealth redistribution and so on and so forth. So we look at all this, the Chicago School and all that, and find out the things that these commentators or scholars tell us about their appreciation of corporate law. Is it really borne out by corporate law as we know it, understand it, and see it on the ground? Particularly so, as almost all of us have actually learned corporate law before, and we have some reasonable appreciation of it. And again, we also need to question whether corporate law, especially so, since just about 2 years, 2019, we in Ghana, we actually sign up to a major piece of the legislative change as far as company law is concerned, referring to the Companies Act of 2019, Act 992. Now, prior to that legislation, there has been a lot of talk about the need to reform certain aspects of our company law, which have been dominated mainly by Companies Act of 1963 at 179. There are a lot of talk about that, various stakeholders, the private sector, Association of Ghana Industries, banks, and so on. So the multi-million-dollar question is this: can we say that the new Companies Act that we have, has it addressed the problems which were identified or perceived prior to the enactment of this new legislation? In other words, we should be able to critically examine the adequacy of Ghanaian corporate law on selected topics. Again, we shouldn't be afraid, having gone through this course, to be in a position to make our own contribution towards what or how best our corporate law should be positioned or repositioned to serve the aims and aspiration of those who use the corporation as a vehicle for doing business. Yeah, so these are some of the modest intended learning outcome which we envisage you will be able to attain by going through this course with us. So therefore, just as we started with Dr. Nkum Menu some time ago, among other things, we will be discussing the critical mapping of the common structure of corporate law or company law across different jurisdictions and corporate law theory. In other words, we will attempt to find out whether corporate law, for example, has some commonalities which you can identify in all jurisdictions where company law exists. In other words, the doctrines, the principles which constitute what we know as corporate law in Ghana, or corporate law in Ghana. Are they unique to the Ghanaian jurisdiction, or there are equivalent constructs? Barima Jakum, can you mute yourself, please?
Yes, sir. Sorry.
Let me do it for you. Okay, all right. Yeah, or there are equivalent concepts, constructs in other jurisdictions. In other words, if we, for example, talk about capital maintenance doctrine in Ghanaian company law, is it a doctrine which is unique to Ghanaian company law, so much so that if we look at Singaporean law, and if they have a company law in Singapore, for example, can we also locate the doctrine of capital maintenance, even if it is not the same language, the same description, or the same taxonomy or lexicon, which is being used to refer to that idea? Can we get a comparable construct? Or if, for example, we talk about, let's say, even like the structure of the board for purpose of corporate governance, how it is envisaged in our law. Is it unique to us? Is it because there are certain peculiar historical or sociological realities in our jurisdiction? Hence, the type or the model of corporate governance which we have, or we are not that different, and what we have here also exists in other jurisdictions, and so on and so forth. So these are some of the things that we want to explore, or even we tell like the corporate vehicle itself. We know that if for nothing at all, the corporate vehicle or the incorporated the business firm as a corporation, within our jurisdiction, that it has a separate legal personality. We can also see the limited liability concept. You can see the perpetual succession, and so on. Now, these things which we see as essential attributes of the incorporated company, are they applicable to other jurisdictions, or they are just unique to us? So those are the kind of things that you discuss with Dr. Menu in your earlier meetings. After that, we will be discussing the theory of incorporation and critical perspective on the doctrine of a separate corporate personality. And of course, we are not unaware that you ought to have some understanding of this doctrine, but we'd like to have a more deeper reflection on it and look at some other dimensions, particularly so the challenges which the concept of separate corporate personality poses to society, at least from where I sit as a teacher and a practitioner, and also as someone involved in corporate governance and some boards and so on. You see how people are being hiding behind this otherwise useful legal concept, get their firm incorporated, and they are, apart from maybe the name, the certificate of incorporation and all that, the company does not really have anything. And as someone would say, it is more or less an empty shell. Empty shell in the sense that it does not have any assets. So therefore, where it is involved in transactions, where it is involved in, becomes indebted and all that, and you were to seal it, you will have a judgment as just a mere piece of paper in your hand. And as we speak now, I have a case where some foreign investors, they have given over $1 million to a Ghanaian in a certain mining business and all that. And if you examine the transaction closely, the foreign investors, some of them also have a company, and the money that they gave to the Ghanaian was sort of given in the name of the company that they have. And they didn't give it to the Ghanaian in his personal capacity. He also gave it to the Ghanaian through the instrumentality of the corporate vehicle, which he is using to do the mining business. Now, current developments regarding that transaction reveal that the Ghanaian has more or less not made progress with the over $1 million. And the foreign investors are angry. They are trying to pursue him and recover their money. But then you are faced with this rare challenge that the vehicle, the company, which the Ghanaian used to collect the money, is separate from him as an entity. And what is more worrying is that you look at the whole surrounding circumstances and you notice that there are no assets, right? No assets which the company, which is indebted, so to speak, actually has. For that matter, if you even went to court and got a judgment and all that, you will not be able to do anything with that judgment. But then you get evidence that the human being behind that has got so much assets. But then corporate law, at least through the separate corporate personality principle we know, says that you cannot, apply the judgment you have against the company to the assets of, let's say, the individual behind the company. And these things I'm talking about is a very serious problem. And as you move towards dissertation, I'll be happy to get one student who would like to do his dissertation on just the separate corporate personality principle and try to do serious research and interrogation and find out if we can make a case whether the grounds for lifting the veil, for example, the bar should be lowered so as to defeat the strategies of those who are abusing the corporate or the separate corporate personality principle and so on. Yeah, so we will be reading and thinking through some of these matters as we move on. And another thematic area we'll also be discussing is a comparative study of formation of incorporated companies or corporations. Here, our interest lies in finding out that if you look at various jurisdictions, right? If we look at various jurisdictions, can we say that when it comes to getting the corporate entity, getting the company or the vehicle brought into existence, getting a company incorporated and all that, in terms of requirements, in terms of processes, if we are to do a very close and rigorous comparison, what can we see? Could we, for example, say that it is relatively easier? It is relatively easier for one to get the company, for example, incorporated, let's say in Nigeria, as opposed to Ghana, or in Hong Kong, as opposed to Ghana, or in New Zealand, as opposed to Ghana. And that is not just unnecessary academic exercise, because there are very important, hello, yeah, I'm teaching, please test me, okay, I'm teaching a lot, thank you, right. So now this we are talking about is not just unnecessary academic exercise, or somebody will say that you are not just being pedantic, or it's not just an exercise in sophistry, but there are some immediate practical implications. Because if you look at corporate theory scholarship, especially across the Atlantic, in the North America, there is this thing we call race to the bottom. Race to the bottom. That is the idea that some jurisdictions would like to make their jurisdiction extremely incorporating friendly. That is to say that very easy to get a company vehicle brought into being and all that. And if you look at the evidence, you tend to get maybe a lot of companies being incorporated in that particular type of jurisdiction. For example, North America, they mentioned Delaware, right? They mentioned Delaware as the most preferred destination for a lot of business firms to get registered and incorporated. a very equivalent to when it comes to the maritime world, right? The maritime world, when it comes to the world of shipping and all that, you notice that there's what they call like the flag of convenience. And for a very long time, those of you remember your international law and all that, you notice that Liberia was considered as a flag of convenience because the legal requirements and the payments and all that for you to get the ship registered and all that was relatively easier. So even despite the fact that they don't manufacture ships in Liberia, if you look at the number of ships in the world, especially the commercial ships, the number registered there will really surprise you, all because it is a flag of convenience. It's relatively easier, not too many restrictions. Now, same idea, mutatis mutandis, applicable to acquisition of the corporate form or the corporate vehicle. For that matter, this third thematic area that we'll be having the discussion and the seminar on, we will look at a number of jurisdictions. Last year, we look at Ghana, UK, USA, Germany, Nigeria, South Africa. You can even add the New Zealand to it and so on. And then we will also look at the World Bank League of Ease of Doing Business. The World Bank has a document we called Doing Business. Now, that document, Doing Business, what it seeks to do is to do something like a league, right? A league in the sense that it tries to, for example, line up various countries. You have more than 100 countries in the world which have been lined up, and the World Bank Ease of Doing Business has got certain parameters, and those parameters relate to the various processes and requirements pertaining to registration of business, commencement of business, governance, requirements, and all that of the corporate entities. And we'll try and find out in which country can we say that it is relatively easier to get a business registered, to get a business up and running in terms of capital requirements, to get the business flourishing in terms of corporate governance, rules, and so on and so forth. So that table is there, and it's a sort of like a link, which is published like almost every year. So you go online. When I finish, I just push some to you, or you can also just Google doing a business, and you notice that we have a lot out there. So we'll also be looking at some of those things to let us appreciate the whether how Ghana is, for example, faring in terms of those parameters vis-a-vis the various countries which are featured in that league. Now, this will also bring us to what we call the corporate transformations and in what we call the arrangement, amalgamation, takeovers, mergers, acquisition, and the capital market regulation. Now, you notice that as far as the world of business is concerned, businesses are highly mobile. Mobile in a number of sense. In one sense, businesses are not necessarily confined to their nationality. If I say nationality, that is the country where they were registered or incorporated, or the region in which they were registered or incorporated. Businesses are mobile, they go to other countries, other regions to also do business or trade. That is one way. Another sense of talking about business being highly mobile is the business environment, various industries are so dynamic that it's in a state of flux. State of flux, that is to say that things are not static. Things are changing every now and again. And what that means is that maybe you are a business company looking at how things are going in a particular industry. You may need to have what they call the synergy, right? Synergy, that is, you may need to have a combination of your resources, your capital, your abilities with some identities so that you become formidable and you are able to harness opportunities which are out there. Now, that may require what you call mergers. You may have to merge with another company, or you may have to be taken over by another. So we'll be looking at this phenomenon of horizontal and vertical integration, combination, and transformations as far as the corporate vehicle is concerned. And I mean, those ones, I mean, you look at Ghana, for example. If you look at, let's say, the brewery industry, you notice that mergers, acquisitions, and takeover, quite rampant. Times that we used to have in the Kumasi here, KBL, ABL, ABC, and all those things. And you notice that some have been swallowed up by others, some have merged, and so on and so forth. You look at the banking or the financial sector, mergers, acquisitions are all over. You look at the telecoms, right? Telecoms, these mergers and acquisitions are happening all around us. I mean, it's gone are the days when the predecessor companies of MTN, almost every 2 or 3 years, it will be sold, another entity will take it, and so on and so forth. I'm sure it's just the mobile money, the Momo, which has made it no longer exciting for them to just sell it and live, because now they're making so much money. And that probably explains why there has been some kind of stability as far as some of these telcos fronts are concerned. And we haven't seen the usual mergers or takeover acquisition, which used to be rampant some years ago. Now, these mergers and acquisitions, as I said, are not only limited to you being in a particular jurisdiction. Sometimes there may be cross-border dimensions. And if we have cross-border dimensions, there are also legal implications, because let's suppose that you have a certain company in Ghana. Let's suppose you have, assuming Africa World Airline, right? It's a typical Ghanaian company. And let's say that they want to go and either take over Arik Air, which is a Nigerian company, and so on. Now, a Ghanaian incorporated company going to acquire a company or aspect of a company incorporated in another jurisdiction, that is a cross-border, and you need to have to appreciate the various legal variations which may be out there. Yeah, so all these things will be discuss. And of course, insolvency law, individual insolvency, and then the corporate insolvency, corporate restructuring. How do you deal with distressed companies? And you notice that distressed companies have become a common phenomenon as far as the world of business is concerned. And the issue which comes up is this. If a company is distressed, do you push the company down further so that it will even collapse completely? Or you can help a distressed company to bounce back rather than helping it to collapse, helping it to fold up, and so on. So there has been that debate. Of course, if you look at the American corporate law scholarship, it is pro giving distressed companies a second chance to, so there's what you call like you allow probably to have like a rescue plan and so on, and you are giving another lease of life, another chance to see how you can bounce back rather than being forced out of existence into some kind of a dissolution and so on. But then, until the Enterprise Act was passed in the early part of the 2000s, if we look at the English corporate law scholarship, it was more, if you like, harsh towards distressed companies, because the idea was that if a company is distressed, that is to say that the directors and all stakeholders, as far as the governance of that company is concerned, are irresponsible or they've not ordered their affairs well. And if that is the case, then they have abused the public confidence reposed in the incorporated entity as a vehicle. For that matter, society should not smile like them. They should be made to push out of existence. But of course, as I said, the Enterprise Act and its subsequent amendments and other legislation have all changed that kind of thinking. And the predominant consensus as far as distressed companies are concerned seems to be that where it is workable, distressed companies should be allowed to get a rescue plan and bounce back and so on, rather than just pushing them out of existence. And of course, that also has implication on the protection of creditors. Creditors, that is those that the company owe, either they have injected their money into the company by way of long-term loan or some other trading transactions. So all these will be discussed as part of this model. And as far as governance, decision-making, managerial direction of companies are concerned, it's not been very simple, in the sense that we look at the business world, the industry, we see crisis here and there. Not too long ago, we heard about the Enron scandal in the US. In Ghana, we hear about, and the Enron scandal, remember how it resulted in the Sarbanes-Oxley Act, trying to create more responsibility on the part of auditors and so on. And you look at our own backyard, the not too long, we highlight the DKM, the DKM which collapsed, and not only the DKM, we have so many banks which have collapsed and so on. And anytime these corporate collapse and corporate failures occur, the tendency is to quickly point at weak corporate governance, poor corporate governance practices, and so on and so forth. Some will say that, well, those who are the helm of affairs, as far as corporate governance is concerned, it so happens that they may not have any permanent stake in the company, maybe by way of equity or some other things. And with that matter, all that they care about, their allowances and other largesse, which accompany their position, for example, as directors and so on. And that means that they are not more careful in exercising judgment regarding various managerial choices. Another group of people say that, well, if employees, for example, are made part of the company, either they are giving shares or other they are giving seats within the governance arrangement of the company, they will feel that beyond their emoluments, salaries, and other perks as employees, they have an enduring stake in the company. And for that matter, it will reflect positively on the company. So a lot of experiments are being done in terms of how to legally structure corporate governance. And should the regulator has more to say and more to do. So for example, when it comes to Ghana, when it comes to, let's say, the banking and financial sector, the regulator has become more and more involved, that where a person is even selected to be a director, you cannot just start exercising your office as a director unless you have gone through approval process and you have been cleared. So there's what we call like the fitness. You have to go through fitness tests and all that. And it creates a number of challenges. Let's say shareholders had AGM. They selected or elected Mr. A to be a director. And Mr. A will have to go through this lengthy and rigorous fitness test or fitness assessment through the Bank of Ghana. And Mr. A does not have control over how long that process will conclude. And not until the process has concluded and he has been given a clean or bill of health in terms of having been pronounced fit to be a director, he cannot start participating in the governance of the company, despite the fact that the members of the company or those whose competent it is to select directors will have selected him. So these are some of the challenges which are coming up. So in a nutshell, these are the things that we'll be discussing in this course. And there is one book I usually encourage students to, I've shared the soft copy with you. That is Crackman and others work, what do you call it, the Anatomy of Corporate Law. There are so many other articles and monographs as and when necessary for a particular topic being discussed, we are going to share with you. And this course is taught mainly by seminar, in the sense that we introduce the topic briefly, and then we direct you on what you are supposed to go and do, read, and then the scheduled class, we come, we raise the issues, and then you do discussion of it, and then you are directed. Any question before we move on? Yes.
Hello, Paul.
Yes.
Hello, Doctor. Please, can you kindly come again with the book that you said you recommended?
Sorry?
The book you recommended. Can you come again?
It's on the distance. It's on the Anatomy of Corporate Law, Crackman. I've shared it with you. Those of you on the platform.
Oh, okay. Thank you very much.
Yes. Yeah, I think it's on the platform. Any other? Although they have a third edition, but what I've shared with you the second edition, but I think the difference is not much. So you don't have to worry. Okay, so let me just a minute. Let's stop here. Get there.
Hello, Doc.
Yes.
In terms of the of assessment, what will the assessment look like? What form?
Oh,
Is
right.
it presented or 10 people or whatever?
Assessment, as you know, we still have the continuous assessment bits, and then we have the end of a semester.
Yes.
So the continuous assessment is 40 marks, and that will be, the seminar and also take home assignment or a term paper, which you are made to, to write.
Okay, thank you.
So that is how it is. So let me show, for example, just for end of semester examination, let me show you a sample of what previously was given. You can just see this on the screen. So this is I'm just giving you an example, like a past question, if you like. So I think this is the last year, okay? This is the last year exam paper, and we're supposed to answer 3 questions. So one question: at the core of corporate governance, the attempt to control conflicts of interest among corporate constituencies. So we quoted something from Crackman, right? And the students were directed to use the agency theory to discuss that observation and all that. And then their response should draw specific aspects of corporate governance from at least 3 jurisdictions which they have studied. And then another one, this one was based upon some seminar and readings that we had done. That is what do you call it? This is shareholder disempowerment versus director's primacy. So there was a question around that. And then the one that we just also did, the incorporation from a jurisdictional perspective. Then we also had questions on the insolvency law and corporate reorganization and all that. So this gives you an idea of what we expect. I hope that helps.
Yeah, thank you very much, Doc. Again, looking at theories of corporate law, how many theories will be covered under the LLM program?
As for
And the agency theory,
theories,
are there other theories?
there are many, but what will happen is that you look at like the most common ones. The agency, theory, the Bell and L, and so on. So as and when you are discussing the particular, I mean, you are discussing a particular topic or particular theme. So the viewpoints out there, then we look at them. So it's not anything for you to worry about. Okay.
Thank you.
Okay, so now let's come to preparation for our first major seminar on the topic 2. I assume that Dr. Menu has done the main topic 1 with you, so we are not going to repeat it. Just so the topic 2, this is what you are going to do. The theory of incorporation and then the critical perspective on doctrine of separate corporate personality. I think that I have also shared this with you on the material that I have put on your platform. And this is, yeah, let me see. Okay, okay, no, I think what I put this there is the topic one, but I'm going to put this there immediately I finish it with you. I'm going to put it on your platform. And ahead of our class next week, you are supposed to do this reading, right? Of course, Mwokwe Nkrumah, the case of Press and Petrodel. And then I would like you to read chapter 2 of a book by Talbot, Critical Company Law. All these are in relation to the theory of incorporation and critical perspective for doctrine of separate corporate personality, piercing the veil, and all that. So we'd like to have a seminar on this. And ahead of that, next week, we're supposed to do these directed readings. And then there's a book by Lord Cook, Turning Point of Common Law. You read just the chapter 1, just the chapter 1. And then there's a very nice article by Michael Moore, Temple Built on 40 Foundations, Piercing the Corporate Veil and Legacy of Solomon and Solomon. These are some of the things that we expect to look at. And all the other things. So like to guide you in your reading, I'll put some questions there. And when we come to have like the seminar next week, I'll raise these questions and then I'll call you and then you speak to them, okay? Maybe I mentioned David Roxon, Tabri Boahin. Can you, share with us what you put down with respect to summarizing the key arguments of Hansman and Crackman in the article Law and the Rise of the Firm, and then how, and demonstrate the extent to which the decision in Press and Petrodel Resources reinforces or undermines the argument made by daughters. So daughters have made certain arguments in relation to this particular topic in the article Law and the Rise of the Firm. And then you have also read the case of Press against Petrodel Resources, right? So if you look at the key decision, the ratio of Press and Petrodel Resources on one hand, and then if you look at the key arguments which Crackman and Hansman are making in this article, will you say that how the UK Supreme Court decided Press and Petrodel, does it reinforce does it support some of the arguments made by these authors some time ago in this article? Or you say that if we pay attention to this decision, is rather undermine or does not support the arguments made in that article. Then so right now, what I would like to do is to, for example, if I knew, and this is going to be the challenge for you, if I knew those who are doing this course, I will have, for example, share these teams to maybe 2 students. You know, 2 students will be given one, and then you go and look at it. But we don't know those who are taking this course. So what it means is that all of you have to read and then think through all this and get your responses ready ahead of our class next week. So unless there are some other questions, otherwise I will end here and send you this and other materials for you to start reading ahead of our class this week. Okay, thank you.
Thank you very much.